Welcome, everybody. My name is Frederik Zuiderveen Borgesius. I'm a law professor in Nijmegen at Radboud University, but I'm also a member of the Meijers Committee. And with our colleagues Marloes Noorloos, Sarah Eskens, Tamara and Willem, we organized this panel on the proposed Digital Services Act by the European Union. And we will focus, because it's a long proposal, we will focus on one aspect, namely what should be the role of online platforms when dealing with extreme speech. And it's a big honor. We have three amazing speakers have found time in their busy diaries to join us. And I'll briefly introduce them. No, I'll briefly say something about the Digital Services Act. At a very high level, the problem is as follows. As we all know, there are powerful companies like social media companies, and in principle, they are good for freedom of expression. They give many people the chance to express their feelings, and they don't have to build their own weblog, etc. So that's a good thing. However, as you know, social media can also be used to spread hate speech and even to incite violence, etc. It makes sense at first intuition then to make these platforms, such as social media companies, to ensure by law that they take some responsibility for cleaning up their own platforms. However, if you make them too responsible for bad speech that happens on their platforms, they may decide in the most extreme case to just ban for all political speech from their platforms. Then there's not much risk for them again, and that would be on balance probably be worse for freedom of expression and would be worse for our democracy. So there needs to be found some type of balance on how much responsibility the law gives to platforms, hosts and social media companies. And that is the underlying theme for many of the discussions today. Now I'll briefly introduce the speakers, and then we'll move to a discussion among the speakers, because we think you have seen enough slides already at online conferences. So we are going to skip the slides and presentations, immediately go to a discussion that could turn into complete chaos, but then at least we hope it will be entertaining chaos. First, we have René van Eyck. He is a senior policy advisor on the digital economy at the Dutch Ministry of Economic Affairs and Climate Policy. And there he focuses on really hard files and dossiers, such as this Digital Services Act, platform regulation in general, and another extremely complicated file, the proposals for an e-privacy regulation, but we won't discuss those today. Next, there's Alexandra Kucherawe, who is, like René, a lawyer, and she's a postdoctoral researcher at the University of Leuven, and she has much experience with research on the liability and responsibilities of intermediary companies like hosts and social media companies, etc., and on content moderation. So welcome René and Alexandra. And the third, there's Gabrielle Guillemin. She's a senior legal officer at Article 19, NGO focusing on human rights and freedom of expression in particular. And she leads the work on digital rights. And in the past, she has also worked at the European Court of Human Rights. And she focuses on, well, digital rights, but with special focus on freedom of expression, privacy, and again, the liability and responsibilities of intermediary companies. So welcome speakers too. Then I'll give the floor in the order to you. First René, Alexandra, and Gabrielle. And first I wonder if you have any first thoughts of how the proposal for the DSA does when aiming to strike a balance between, on the one hand, fighting speech that is too extreme, like speech that incites violence or racism, and respecting freedom of speech. What do you think of the proposal at first glance on that balance? René, any first thoughts?
Yeah, well, so first of all, thank you, Frederick, and of course all the members of the Meijers Committee for inviting me to this panel discussion. I really look forward to this exciting discussion about an ongoing file that I think will, you know, keep us busy for the foreseeable future. I'll keep it a little bit short, just on that question, how it balances between freedom of expression and sort of the need to create a sort of safer online environment, which are the two objectives of the DSA proposal. But I think one important comment that I would make to start with is that when it comes to content moderation online, and specifically the removal of sort of content online, I think all the discussions sort of boil down to two fundamental questions, which is where do we draw the line, and who draws that line? And I think for those two questions, I feel the DSA does provide, you know, good answers in the sense that the procedural obligations that deal with removal or must carry decisions by platforms. So we're talking about the notice and action mechanism, the trusted flagger system, but also the measures against misuse that platforms can rely on, apply to illegal content only. And that is important, I think, because the DSA doesn't define substantively what constitutes illegal content online. It merely sort of refers to a union law or the law of a member state to determine what is illegal or what isn't illegal. And I think, in other words, the question, you know, where do we draw the line between and who draws the line between what is legal and illegal is left ultimately to democratically elected EU and national legislators. And I think that should be the case. And I think that is a good thing. So I think I would start maybe with that comment. You know, I don't want to take up too much space here. I mean, you know, we have very co-esteemed panelists here, so I wouldn't want to take up more time, but I think that's an important comment to start with.
Thank you very much. Good point indeed. What is illegal is defined elsewhere, not in this proposal. This proposal, in summary, describes procedures on how to deal with it. But you speakers are more specialized than me, so please interrupt me if I'm summarizing too roughly. Alexandra.
Thank you, Frederick. Hello, everyone, and thank you for having me here. So I might go for a little bit longer, but that's just blame it on my academic position. But I thought I would start with some basics about the right to freedom of expression, which I think are worth remembering or reminding in this conversation. So first of all, the right to freedom of expression in Europe is not absolute. Restrictions may be permitted if they're prescribed by law for protection of legitimate aims and necessary in democratic society. But there's also a special category of speech, hate speech, that is not considered worthy of protection. But there's no one uniform definition of hate speech agreed upon in different human rights instruments. So the European Convention on Human Rights does not provide a specific definition, but instead it prefers a case-by-case approach. There is also Article 17 in the Convention, sometimes called guillotine provision, which basically says that Convention does not protect activities that are aiming to destroy any of the rights or freedoms in the Convention. And this provision has been applied to promotion and justification of terrorism and war crimes, incitement to violence or hatred, negation of Holocaust, promotion of totalitarian ideologies, but also threat to constitutional order, including speech that endangers free operation of democratic institutions, or that is trying to destroy stability of a democratic system. But hate speech is also used more colloquially. And then, it can refer to basically anything that people feel offended with or attacked with or criticized with. Sometimes it is very easily used by politicians, for example. But at the same time, we should not forget that under the convention, speech that is offensive, shocking, or disturbing is still protected. And the court has stated it already in 1976 that this broad-mindedness and tolerance of unfavorable ideas is actually one of the foundations of democratic society. And then we have extreme speech, which is the topic of our webinar today. And I have to admit that when I saw that, I really started wondering, okay, what does it mean, extreme speech? So as was explained in the introduction, it covers hate speech, but also expressions such as glorification of terrorism, or denial or minimization of gross fundamental rights, human rights violations, but also blasphemy. And I was also looking at definitions in the communication studies, and then they refer to online vitriol and aggressive or abusive speech, which of course makes it broader category than hate speech in the understanding of the European Court of Human Rights. So it seems that extreme speech is not a clearly defined category, and certainly not one that fits easily into the standard division between lawful and unlawful. But when speech is restricted, which it may be, it should be on the basis of clear and predictable rules that are accessible for everyone, so they could know what kind of behavior is expected of them and what kind of consequences that could face if they don't follow it. And it should also be clear what kind of speech the restrictions apply to. And in the online environment, providers of online services are increasingly responsibilized for the speech of their users. And that approach may seem efficient, but of course it raises a number of concerns. That decisions about speech are delegated to entities that are not competent to make these type of judgments. There's no proper balancing of rights at stake. It may lead to over-removal of legal content, and as a result could affect fundamental rights of internet users, administered through through restrictions by private entities. And now enters the DSA. Frederick, are you showing me to wrap up?
No, I was. So we may have audience members who are not as specialized as we. So perhaps you could briefly explain where a risk of overblocking could come from, and what do you mean with the phrase risk of overblocking?
Okay, well, maybe I'll just still make my comments. I think it will be clearer in a moment. So the DSA, so it's primarily targeting illegal content. It does mention hate speech as an example of illegal content. It also talks about manifestly illegal content, which is understood as information where it is evident to layperson without any substantive analysis that content is illegal. So it could be hate speech, but not always, or not necessarily. These two terms are not equivalent. The DSA does not mention extreme content as a concept or as a term, but it does contain several provisions that would extend the scope to content which is not illegal, but it could be harmful or extreme. Also what is sometimes called lawful but awful. And that this content could be prohibited by the providers through their private ordering. So in the DSA, we have Article 6 on voluntary own initiative investigations, Article 12 on terms and conditions, Article 26 on risk assessment, and combined with Article 27 on the mitigation measures, Article 35 on codes of conduct, and Article 37 on crisis protocols. And yeah, I wanted to say a few words about Article 6, but I'm not sure if that's okay now, or you want me to keep it for later. I'll just go on. You stop me when needed. So it addresses voluntary own initiative investigations, and they're aimed at detecting, identifying, and removing or disabling of access to illegal content. But it also refers to measures taken to comply with providers' terms and conditions. So that could include extreme speech if that is prohibited in the terms and conditions. And this provision attempts to incentivize providers to take more initiative, but without immediate risk of losing immunity, which was a situation under which is still a situation under e-commerce directive, when providers taking too much voluntary measures could be considered as active hosts and therefore lose the immunity. The provision furthers policymaking and makers' goals to have intermediaries do more content policing, but that would most likely lead to more removals of content. And of course, this is not to say that we shouldn't worry or do anything about extreme speech, but the problem is with content that is shocking or disturbing or even offensive, but it's important for public discourse on the matters of public interest. And this is that type of content which often suffers from over removal. Why? Because it is safer approach for the providers to make sure that they do not become liable for the speech of their users. So for me, this is something that is, that encouragement to remove more voluntarily is at odds with one of the goals of the DSA, which is to ensure more protection for fundamental rights online and especially freedom of expression. But that's not all. When reading recital 25 of the DSA, you could conclude that actually taking voluntary actions, even in good faith, doesn't guarantee but also does not preclude neutrality, on which then, qualification for immunity would depend on. So the possibility of losing immunity still exists. So we see on one hand, encouragement to take more voluntary measures to tackle illegal content or content prohibited through terms and conditions without ensuring full immunity. Even if the activities are not successful or are conducted, not diligently. And that risks creating legal uncertainty in practice. On the one hand, the provision could create more risk for effective exercise of the right to freedom of expression because it encourages more takedowns. And on the other hand, it is not creating any more predictability for the providers who actually may want to take certain voluntary measures to tackle extreme speech, for example, through their terms and conditions. I'll stop here, but I'll be happy to continue. Thank you.
Thank you very much, Alexandra. And Alexandra mentioned indeed the current situation in Europe is still based on a directive from 2000, so which was drafted in the late 1990s. And that is called the e-commerce directive. And very roughly summarized, that e-commerce directive has rules for hosting companies. Classical hosting companies that host a website for somebody else. And the current rules say, in short, if a host is neutral and doesn't influence the content that is hosted, then it's not responsible even if it hosts horrible stuff. And back then, the reasoning was, without such a rule, nobody would have the guts to start a hosting company. That would be bad for the World Wide Web, would be bad for the economy, and would be bad for freedom of expression. Back then, that seemed to make sense. However, nobody foresaw that within a couple of years, the most powerful and rich companies in the world, the YouTubes and the social media companies and the Facebooks in the world, would invoke those same provisions. Like, yeah, we host content for others, and now we don't have responsibility either. And the current rules have a somewhat strange effect that if a company starts cleaning up its videos, for instance, if it does so too enthusiastically, it risks becoming so active that it cannot rely anymore on the current shield for liability. And that is partly what the DSA tries to address. Gabrielle, any first thoughts?
Thanks very much, and thank you very much for this invitation. Very excited to be here today. So I think I'll try and address 3 points. The first one is in relation to extreme speech. The second is a few reactions on the DSA, and 3, I'll have some quick reactions to what's been said before. So first on extreme speech. I mean, I think here it's, I could summarize as a big +1 to what Alexandra just said, which is that it's a term that really doesn't say very much about the substance of the speech itself when you look at its ordinary meaning. And so in practice, that means it could cover speech that's illegal, but equally speech that is perfectly lawful. It's just a qualifier. It's just the same as saying someone has radical views on an issue. So that's why it's a slightly tricky term, which I completely understand for the purpose of making this conversation interesting, but it also makes it more problematic when quite often, and this is an area that Article 19 works on quite a lot, is terrorism, and you end up having this sliding scale. You go from terrorism, and all of a sudden, because terrorism implies a very security approach to the issue, sometimes to talk about what happens in an education setting or others, like or trying to have a slightly less security approach to the issue. Then you talk about violent extremism, but then you slide into extremism as well, and hate speech. And so you have like this sliding scale between all these various terms that makes it all very confusing. But as René told us earlier, the DSA really is content agnostic in many ways. And so it's really, you do have a set of rules that on notice and action in particular that are very much focused on illegal content that it doesn't define. And it in a way indirectly deals with the rest, including the lawful but awful, through other means. And so that's the various things that are mentioned around terms of service and various things around due diligence obligations, which is actually one of the big innovations of the DSA. So now moving on, so more specifically to these rules and what does well and perhaps not so well. I mean, very generally speaking, I mean, there's a couple of things that we as civil society have generally welcomed in the DSA, and these things have a lot to do with, well, for instance, to begin with, there's much more recognition of the need to protect fundamental rights. And so you see that mentioned throughout the DSA, which is positive and a change from like how things were addressed before. The second thing is transparency obligations. There are a lot of transparency provisions in the DSA, which are very positive in terms of society, us, the public, better understanding what's happening within those platforms, and therefore offering the opportunity of a beginning of accountability in that sense. And that leads me to the third aspect, which is like really good in the DSA. And of course, we can discuss the detail and so on, but it's really like provisions around access to data, because the truth is, by and large, we don't know very well what's happening. And to the extent that companies are taking measures to address various problems, we actually don't really know how effective they are, because we don't really have the data. It hasn't been audited independently. So all we have to do is rely on the information that we're being given by the company. So this is all a plus. Now, to the things which we see as not being also good for free expression. And now looking at the notice and action mechanism. So I think a lot of the issues have already been addressed by Alexandra, but I'll just get back to it slightly. So the notice and action procedure says that effectively when you have someone filing a notice with a certain amount of detail, once that notice is filed with the company, then the DSA clarifies, which wasn't the case beforehand under the ECD. So in that sense, it's an improvement. It's for legal certainty. It says that the company will then have actual knowledge of illegality. And so that means that if the company sits and does nothing, well, it risks losing immunity from liability, and it could be sued. It won't necessarily be found responsible, because that's a question for the domestic courts to decide. But there is a significant risk on their side that they'll be found liable. Now, I think the big problem with that, which again, Alexandra was alluding to, is that particularly if you're a small company, it's very unlikely that you'll be able to hire an army of lawyers to deal with the very, like, if you want to have a business that works, you need to have a good user base. So you won't be able to really, you know, you won't have like the resources to look at all the notices and really try and decide whether or not you can take that legal risk, because that means you'll have to figure out, okay, do we think that if we were taken to court, would we win this one? It's much easier to just remove the content, because that makes the problem go away altogether. And so there's very few companies that could do this. And that's why it has a chilling effect on freedom of expression, because it's much easier for someone, even if there's requirements in there for quite detailed information, which is one way of protecting free expression indirectly, it's much easier to say, well, look, I just got this, you know, I don't want to deal with it, I don't want to risk it, you know, I'll just remove the content. And that's how you have a chilling effect on free expression. And another problem with the procedure is that all this happens without even the person being notified before the removal takes place. So there's not even an opportunity for the other side to be told, hey, look, you know, we've received this complaint, someone thinks it's illegal. So, you know, what is your view on this? And so that's also a due process issue, because the decision, the like interference with speech, happens without the person being given a chance to put their case. And so that's another issue with the notice and action procedure in the DSA. And so, and that's why, like Article 19, as an organization, we've long advocated for two things: a notice mechanism, which tries to basically put the issue back in the hands of the parties themselves, the person complaining and the person who wrote the content at issue. And also, of course, particularly for criminal type content, the courts. And so that leads me to some quick reactions to the discussion earlier. I think René said, where do we draw the line in the DSA? So I think like the DSA doesn't really draw that line in many ways. As I said, I think it's content agnostic. And who makes the decision? And here, what's happening with the proposed notice and action mechanism is that it puts the decision on illegality. It puts it squarely with the companies to make it in the first instance, which, you know, as we've discussed, is disquieting. That sort of decision would be made by these companies, and as I said earlier, also in many instances, they wouldn't even have the resources and capability to make that assessment. Now, to I think a point that Alexandra was making around like the hate speech and the case law of the European Court of Human Rights, and she was pointing out that the decisions are made on a case-by-case basis. And I think here, like really the challenge that we have, and you know, that the technology and social media companies have thrown up at us, is scale. Yeah. Because it's extremely difficult to do the things that are often demanded, like, and you know, we haven't even talked about, like, for example, sometimes there's demands for removal within like particular time frames. So that means that for this to happen, you need to have automated systems, and all of this happens without necessarily even a human being in the loop. And so the default tends to be very much towards the removal of content almost by default, if you like, through various means, and the, you know, how the terms of services themselves are framed. And all you have to help you from a free speech perspective happens afterwards. It's ex post facto. It puts all the burden on having effective complaints mechanisms within the companies, which not a lot will be able to do. And then later on being able to have some kind of dispute settlement mechanism or access to court, which again, not always easy. And I'll stop here. Thank you.
Thank you so much. I already realized that our 1.5 hour panel is going to be short for so many interesting angles. I'm going to give all of you another chance to react to each other. And perhaps I understood from especially Alexandra and Gabriele that you see a risk that the DSA pushes companies towards removing too much. So perhaps you could say a bit more about that, or you can react to each other. And if you want, you can also say something about the following. A couple of you mentioned the existence of terms and conditions. And so we are in a situation where there's so many comments put on social media, so many videos uploaded on video sharing platforms, etc., that the solution that we would think of 3 years ago, namely let judges decide, that doesn't work on this scale. And so we have the problem, it is companies doing it themselves. And is it reasonable if they follow their own terms and conditions? Can't we just say follow a human rights case law when you decide on what you remove or not? Yeah, so we'll do the same order again. René?
Yeah, sure. Yeah, maybe just really quickly, starting with Alexandra's comments on Article 6. So this sort of, you know, this is informally dubbed the Good Samaritan clause, but it doesn't really translate so well because, you know, it's a US sort of concept, and, you know, in Europe we have our own sort of
Could you remind the audience again what Article 6 says?
Yeah, so Article 6 is basically say what Alexandra just talked about, says that a company doesn't lose its liability exemption if it proactively searches for illegal content and removes it or disables it or whatever. And it's meant to sort of stimulate companies in sort of taking responsibility, you know, what happens on their services to sort of make sure it's safer. And so I would argue, I mean, I see sort of the risk, but I would also argue at the same time that actually it sort of removes some of the risks of companies erring on the side of caution, as in just removing it simply because there isn't any time. As you know, as if it's sort of notified to them, they have to take action. This actually helps them to sort of look at it without this sort of risk hanging over their heads, you know, saying that if you don't remove it, you're going to be held liable. And I think that's also maybe a quick side remark. It's important to distinguish between liability and responsibility. What the DSA does is it maintains sort of the liability exemptions that we have in the e-commerce directive. So this, you know, over 20-year-old law sort of, and the DSA sort of almost, you know, to 90%, let's say, transposes these liability exemptions for companies. And the reasons why it does this is because exactly that reason. We fear this risk of over removal if you don't have that liability exemption, that shield sort of, that limited the safe harbor regime as they call it as well. Because if you don't have that, then companies might simply say, well, there's so much material that's being uploaded, I'm just going to play safe and I'm just going to remove anything that even looks suspicious, you know, like I'm not even going to look at this and just decide on the safe side. So I would argue Article 6, this Good Samaritan clause, might actually be helpful in sort of stemming this risk of over removal in a certain degree. Then more generally, maybe responding to the comments that Gabrielle made on the notice and action mechanism. It's very true, it's an ex post facto system. So, you know, first first a notice happens, but the decision has already been made, and then you can launch your complaint if you're not happy with the decision that's been made by the platform. But what is good to mention is that there's a range of due diligence obligations that these online platforms are subject to, and those include internal complaint handling mechanism, a out-of-court dispute settlement mechanism, and of course always the possibility to sort of seek judicial redress. And I think this is something that's really important, because this wasn't the case in the e-commerce directive. It wasn't spelled out, at least positively, and now it has been. And I would say those are what we call the responsibilities that have been sort of added on to these online platforms. And I think that's a good thing, because in a way, of course, if a decision is made by an online platform that where you dispute the legality and say, well, this was a legal speech comment statement that I made, you have access to 3 sort of courses of avenues, and you can do them simultaneously. So they're not mutually exclusive, they're not exhaustive either. So you can easily go to an out-of-court dispute settlement mechanism or seek judicial redress at the same time. And it's meant to sort of provide the users or empower them to dispute these decisions that are made by companies. And of course, we always need to be mindful sort of that these are sort of they are low barriers, right? Like they should be easy to sort of go to as an individual user, because they shouldn't be too costly. You should have easy access, sort of. And I think the DSA does this reasonably well. Of course, we're still talking about the details, and we're still going to amend the text, so I can't say too much. But I think from a starting point, I think it does it pretty well. So I would just say sort of give you that comment too. And then in terms of scale, you mentioned Frederick. That's true. I mean, I think it's almost also unrealistic, to be honest, because I understand this very well. I mean, ultimately, of course, the real decision on what's legal and what isn't legal lies with the courts. It's the exclusive realm by courts. But you have to also remember that there's probably 1,000 or 100,000 notices that are uploaded, and you can't overburden the judicial system either. And this is why they have created this out-of-court dispute settlement mechanism in the first place. One important comment with that, though, is of course that the out-of-court dispute settlement mechanism then needs to be independent. And the word independence, I think, is maybe a bit of a contentious topic, where you need to make sure that these aren't politically motivated dispute settlement mechanisms, or maybe biased mechanisms where an end user doesn't get its rights vindicated. So I would just sort of leave it at that for now. But I do agree. Also, the DSA, I like the content agnostic definition that you used, Gabrielle. That's true. And I would just leave it with one more comment about the DSA. What it also does, it does sort of look into certain forms of harmful content. If you look at Articles 26, and that's what Alexandra earlier referred to. And what it does really well there, I think, which is positive for freedom of expression, is that it sort of looks more at regulating the conduct of online platforms rather than the content removal itself, sort of, because it's so awful, but not necessarily illegal sort of content that we look at. So that's what I'll leave it with for now, and then happy to hear.
Thank you so much. Could you briefly say for audience members that didn't have the time to go to read through the enormous pile of paper that is this proposal, could you briefly summarize what does the DSA require in terms of out-of-court dispute settlement system?
That's a good question. I might have to take the text with me here. Like, I have to go through it myself all the time. But basically, what is maybe also important to mention is that these out-of-court dispute settlement mechanisms only apply to online platforms. So what the DSA does is it sort of categorizes different intermediary services that we just talked about. You talked about the hosting service providers, and that's a big category in the e-commerce directive, because back in the day, of course, we didn't really have the Facebooks and the YouTubes of the world. But what the DSA does now is it's sort of added a subset of hosting services, which are online platforms, and those subset of hosting services have additional responsibilities they have to comply with. And one of them is to create a out-of-court dispute settlement mechanism. The exact requirements, I'd have to look at the text, to be honest.
No,
I don't know it out of my head. Yeah.
This is a perfect summary.
I don't work for the commission, unfortunately, so I can't tell you that. Yeah.
By heart, so I'm very impressed. And it's good that you mentioned indeed that in DSA, there are more responsibilities for, in summary, bigger companies. Gabriella, I give the floor to you.
Thanks very much. Just a couple of reactions to this on the company's terms of service and like the due diligence obligations. I think it's I think it's really like the newest, more innovative part, I think, of the DSA. And I think it follows on somewhat from a discussion that started in the United Kingdom and France on a duty of care and online harms, I believe. And in France, there had been a Facebook mission where they'd been looking at, you know, how there could be a review of like the systems and processes of the companies when they carry out content moderation. So now, like it's the due diligence obligations are in Article 26 and 27. And effectively, they mandate the very large online platforms to carry out these risk assessments in relation to three things. One is the dissemination of illegal content. The second one is negative effects on some fundamental rights. And then there is another one, which, as René mentions more explicitly some kind of content, and it is the intentional manipulation of, well, I don't have the exact wording in mind, but effectively, it seems to be aiming at, you know, when you have like what the companies themselves often call coordinated and authentic behavior, which is like bots and things like that, that aim to manipulate. And so that's why like they're looking at the impact on civic discourse, public health, public security, and I think there's something that I'm missing. And so I think from Article 19's perspective, and so once the risk assessment's been done, like the companies are expected to take some risk mitigation measures, and so looking at their systems and their operations to try and counter that. And then whether or not they do the right thing is something that is actually ultimately overseen by, you know, it's a mixed oversight mechanism, but like the ultimate regulator is the commission, but it's also acting with the advice of a board of digital services coordinators. And so the regulators effectively would be looking at, okay, have the companies done enough to respond? Like, have they taken the right measures and so on? And so, and of course, if they don't, then you have like sanctions that might kick in, particular fines. And so I think for us, like some of the key issues are like how broad this provision is. It's in fact very broad. And I think the thing is, it's actually part of the point, because it's meant to be future-proof and flexible because the technology evolves. But from a rule of law, legal certainty perspective, it's much more problematic, because that means that it gives an awful lot of discretion to the regulators in concert more or less with the companies to come up with what they think is, you know, what are those reasonable proportionate measures. And so that's a concern. And for an organization such as ours working around the world, knowing that the regulator would never be independent in some places, for us, that's definitely a concern. That's a concern if that means, and you know, the way it's worded is not impossible, it's a concern if that means that they could say, well, really, we think you should change your terms of service so that you ban this type of like lawful but awful content. You should change your terms of service. You could say make them more transparent, but in fact, it means changing them so that it can catch more types of what you might call extreme speech. It's also something that, and it's actually an example that we have in the UK. It seems like, because there's been a push to undermine end-to-end encryption, for instance. But if the language is sufficiently broad, it's not, outside the realm of possibilities that, a regulator might say that the company should adopt all these measures, for example, to protect children, but that have an undue impact on the privacy of users at large. And so, and so that's to me is the problem with this provision, is that it's not, because it's not setting out clearly what needs to be done. It still leaves an awful lot of scope for measures to be adopted, which we've been contesting over the years as ways of dealing with certain problems, but you could still reintroduce them via these provisions. And another thing that this provision doesn't really recognize, or doesn't really provide any guidance on, is that rights conflict. On the one hand, you might have like the freedom of expression of someone, and on the other hand, their right to privacy. And it's a balancing act. And as Alexandra was saying earlier, there is case law, it's case by case, it's a balance of various factors that have to be looked at. And so the DSA doesn't really give guidance on where that line should be struck when that happens. And so that's for all these reasons that we have some issues with these provisions. And I guess your initial question, so it's been a long reaction, so I don't want to take up too much time. And I think it's been partly covered. It's around like the terms of and conditions of companies, and whether it's fair enough for them to have those and so on. I suppose, 2 points here. One is, I think the rules should be designed in such a way that you still leave, you don't want to have like a uniform, like everyone living in some kind of Facebook environment, for instance. Like, you want to be able to have different experiences on different platforms. And that means that you should be able to have platforms that perhaps are more restrictive because, they want to be very protective for kids. So that's fair enough. Or you want to have like platforms where it's more robust and, you can engage in like difficult topic and so on. So I think you want to make sure that, that there is flexibility here, and, to allow that plurality of views to take place, because that's what democratic societies are all about. Now, when it comes to the larger one, which is my second point, like for example, Facebook or YouTube, I think what's a little trickier with them is that because, they've been assimilated to like a kind of public square, and they've become so big and so on. So I think here it becomes a little trickier, and that's why we tend to think that it's useful for them to look to international human rights law as guidance. It won't be exactly the same because, we're not talking about the criminal law, things like that. But equally, it still takes you, hopefully a bit higher up in terms of, again, allowing public debate. And so that's where you would have like the sort of rules that tell you, well, right, public figures, political speech, actually, because it's not public figures per se, it's really political speech that's highly protected. So you want a high level of protection for that. But, international law will tell you, well, the buck stops with incitement to violence. So, and that's fine to take measures there. And so I think that's where, really, international human rights law can be a useful guide. And that's all the work that's been done in the past by David Kane. But I'll stop here. So thanks very much.
Thank you very much. I realized that I messed up the order, so I may have confused you. Apologies for that. Alexandra, you have the floor next. And meanwhile, René and Gabrielle could perhaps, with one, I look already at the questions that have been asked in the chat. So in the next round, we could also consider those questions. But if Alexandra says something that you completely disagree with, or me, then you can also react to us, of course. Alexandra.
Okay, so no problem, and thank you, Frederick. So, bunch of things that I would like to say. I might forget some, but okay. So, quickly with regard to Article 6, I totally understand and see how that was the intention. I think for me, this is maybe some of the wording issues. So if that part on, you know, they should not lose their status, or they should not be considered active solely because of these measures that they take. But that's like, for me, it means that they could still lose that, possibly because of other issues, especially if there is, it could be established that they have knowledge. So I understand the intention. I think that's maybe, you know, some phrasing or some wording that could be clarified here to also make it, you know, more clearer and more foreseeable, more predictable. And that, you know, maybe I could use it to link with the discussion about knowledge. Because that is something that, you know, it was already criticized under the directive, that division between actual knowledge and constructive knowledge. So what the directive, and now the DSA repeats, calls the awareness of facts or circumstances from illegality is apparent. And that was a difference in terms of like, okay, for criminal liability, you would have to have actual knowledge, but for damages, constructive knowledge, so this awareness was enough. But it was never clear, and it was interpreted differently in different countries. What does it mean? What is the difference? What do you need to have actual knowledge? Do you need the court order, or is that a notification enough to then talk about actual knowledge? And for me, this is something, as René mentioned, you know, a lot is incorporated from the e-commerce directive, some of the definitions and approaches. And that for me is something that is still not clear. Because in every article that mentions knowledge, it is always actual knowledge or awareness. So that's something that I think maybe, you know, there is some missed opportunity here to at least introduce a little more clarity. In my research work, I was arguing that, you know, for actual knowledge, it should be a court order. But of course, I do recognize that that there is a scale issue here. But in terms, you know, if we're talking about criminal liability, then, you know, let's say the speediness of procedures and efficiency should also not kind of be considered as a factor when we talk really about rights and freedoms. You know, protection of these rights should not be like inconvenience, let's say, in terms of efficient procedures. Also, yeah, I definitely agree that, you know, DSA is talking about procedures and not and it's content agnostic, and that's for me, that's also something that I was writing about a lot. You know, that we need these procedural safeguards to ensure that the process is clear, is predictable, takes into account balancing of rights. I propose number of safeguards, for example, in terms of procedural fairness. So something that Gabrielle mentioned, that, you know, we have number of safeguards, and I have to say that, you know, I was very pleasantly surprised, but a lot of them, you know, they apply after the content is already taken down, right? So you get a notification about the decision, and you could possibly appeal this decision, and you have number of options to appeal, but your content is already down. So, you know, it's some people will use it, not everybody. But, and of course, this idea that it's very easy to remove your content, but you have to go through a long court procedure to have it reinstated. It's also maybe not exactly equal positioning here. in terms of proportionality, what I was also saying that, you know, we could make a distinction between different actions, because when we talk about notice and actions, there is number of actions possible. And here I have a feeling that DSA is still very much focusing on removal or blocking, and like notice and all these, let's say, less extreme or less radical responses are not necessarily taken here into account as a possibility. What else? Yeah, the safeguards for procedural fairness. So notifications to the content provider, yes, but it would be great if that could be done before the content is taken down, and that would indeed introduce some due process elements and some you know, elements of equality of arms and adversarial proceedings, that you have a right to defend your content or your use of content. So I think in general, as again, I am very happy that there's so many safeguards introduced, but I think there is still some room for improvement in terms of details if we really want to you know, have the effect that it actually actively protects or facilitates effective exercise or enjoyment of the right to freedom of expression. Then what else I wanted to say about if we should let platforms or service providers to, you know, really decide on their own in their terms and conditions what kind of content they allow. So for me, this is something that I also always go back to the convention and decisions of Court of Human Rights, that, you know, we do have right to freedom of expression also protects companies. It's not only for private individuals. We also have right to conduct business. So, and even though, you know, I always throw in positive obligations by the state to actively protect freedom of expression of their users, also from interference by other private companies, like it would be a case here. But at the same time, there is no freedom of forum. There is no, you know, this must carry obligation for any kind of content that is not illegal, right? Like Gabriel mentioned, there could be thematic platforms, and it's definitely not, it's not a purpose to have everybody carry the same content obligatory because it's not illegal. Platforms for children could have different rules. Okay, the always thrown an example between for platforms for cat owners, right? And then they have to carry dog pictures. So of course, platforms can have certain decisions and make certain decisions, certain choices, what kind of content they allow, they want to see. And I think that is that element that has to be taken into account. But yeah, for me, this is more about, okay, if the terms and conditions are clear, and again, people know what is expected of them and what is not allowed on the platform. If there is a procedure to appeal, that's great, you know, and the whole process to in case of a conflict. So for me, and that's maybe I see there's Trump questions thrown in. So that's actually I think maybe could be linked to here. You know, we had a lot of discussions on this, and I'm not sure I have no, I don't have all the answers, but I was looking at it from the perspective of European right to freedom of expression, and exactly this, that you know, they don't have an obligation to carry all the content. I think it was one of the issues there was that, you know, there were certain terms and conditions that were applied to, let's say, normal people, but exceptions were made for him, while at the same time in other countries the platforms were not so keen on giving exceptions to the heads of states. So I think, that for me, there is definitely argument in saying that if you do have rules and if you have certain policies on types of content that you don't want on your platform, I would say that should be applied uniformly to everyone, because for me, we had all these politicians, some politicians being shocked and how is it possible that a platform can silence a president of the US? At the same time, many of these politicians in Europe actually do invite and encourage and push platforms to, take more content down and act faster. So there was, for me, maybe certain irony there. And I think in discussions on freedom of expression, it is easy to fall into that trap that, we're very much pro freedom of expression when it's my speech, but when it's somebody else's speech, then it's that's different. So for me, and what I'm trying to get a committee which has this Trump amendment, which for me actually was quite surprising to see. And let me see, it's quite short and I have it open somewhere. I will read it to you.
Alexandra, perhaps you could postpone some of your comments to the next.
Oh yes, sure.
Thank you.
But Trump amendment, I will get back to that in a moment.
Perfect. So now I'll do René, Gabrielle, Alexandra. Perhaps you had time to have a look at the chat. Don't just react to what you feel comfortable reacting to. You don't have to react to everything. First, René, please.
Yeah, thank you. I've got 4 comments, but I'll try to do it really quickly because I feel like I'm taking up a lot of time with people that know far more about it, I think, than I do. But maybe firstly on the actual knowledge and acting expeditiously that Alexandra talked about. I agree with that because simply, so maybe just to explain also to the audience, just in case, but those 2 elements are sort of necessary to establish whether you are exempt from liability for certain illegal content that's uploaded on your services or not. So if you meet those 2 conditions, you had actual knowledge and you acted expeditiously, then you're not liable. If you don't do that, then of course a liability kicks in, sort of. And I think it is a good comment to make that maybe could be clarified a little bit more. Also, because if you clarify those concepts, then you have this risk of over removal is diminished, hopefully somewhat. But I think it's also important to maybe explore a little bit the relationship between those 2 concepts. So actual knowledge and what is expeditious. So how fast should you act after having actual knowledge? Does it depend on sort of the type of content that you find? Does like that kind of stuff, I think needs some clarification. I mean, you could imagine, for instance, that awful material like child sexual abuse material. I mean, this is a very this is manifestly illegal. Of course, this goes without saying that that is material that we don't want to see on platforms. You could imagine that you can interpret acting expeditiously slightly different in that sense than maybe other content where you have to maybe establish legality or illegality first. So I think sort of trying to explain that relationship a little bit more, and also sort of trying to define that a little bit better might be helpful in reducing that risk of over removal, I think, for companies. So that's first. Secondly, freedom of expression that you also talked about, Alexandra, I think. Sorry if I get it wrong, if it's Gabrielle, but you said there's also freedom to conduct a business, and I think that's a point I actually wanted to make in my opening statement, but I didn't do it because I thought it might take too long, sort of. But I agree with that. I mean, it's up to businesses really to set their own terms and conditions. I mean, they're allowed to do that. I think that's perfectly sort of normal. And I think an issue though with that one, and that sort of ties in with the Trump ban, I think, is that they've been doing it perhaps a little bit inconsistently. so far. And that has really led to quite the outcry from the public and politicians as well, I think, saying like, why did you decide, differently before? And all of a sudden now, that, his presidency is coming to an end, you're banning him, and I think that's a good thing to sort of, and I think this is where the DSA comes in, because the DSA does provide these transparency obligations that Gabrielle already alluded to. So at least we'll know now, like, why it is that a certain platform took a certain decision to suspend the user or account, or to remove content. So they have to motivate their reason why they deleted something in the first place, or didn't delete something in the first place. So I think that's sort of where the frustration lies, and I think that's where the DSA comes in quite handy. I think, yeah, as for the other questions that I see here, maybe the first question on the relationship between the GDPR and the DSA. Yeah, I mean, I'm not a GDPR expert, to be honest. I leave that, I think, to other legal experts. But the DSA does really clearly spell out. Let's maybe also mention this: the DSA is a horizontal legislative framework, meaning that sectoral sort of laws are lex specialis, so will always prevail in the event that they conflict with the DSA, and that's also spelled out in the DSA itself. Now, of course, there are probably some examples that we could come up with, or some instances where that might be a little bit tricky, because there's more sectoral laws that the DSA sort of conflicts with. But generally speaking, the law, of course, is that those sectoral laws would prevail or supersede over sort of the more general horizontal nature of the DSA. So I hope that maybe answers that question a little bit.
Thank you so much, René. An interesting idea that you suggest that differences could be made for different types of companies. Indeed, I could imagine that you say for revenge porn or child abuse, takedowns should be extremely quickly. Well, personally, I could live with the fact that copyright infringing material would stay on a bit longer, for instance. And you could perhaps think of different rules and expectations there. That would bring the DSA, that would make the DSA also less content agnostic, by the way, but perhaps that makes sense.
Yeah, maybe sorry, just to clarify, I'm not saying, because we sort of, what I think is important is to say there are already very many sectoral laws, right? Like the Copyright Directive and, like all these ones. So those are in place. If there's a specific sort of dispute over specific types of content and specific types of providers as well, then you have to go to these different sectoral laws to see what the answer is. Whereas the DSA is sort of there to complement the voids that are there, sort of. And I think that's something that we should keep. So I don't think we should move away from a content agnostic. I love this term. I'm going to use this, by the way, this terminology. I think it's great. To a more content specific, because that sort of destroys the nature of the DSA in the first place. But what I do think is, and this is what Alexandra so eloquently said, sort of, is you have to clarify perhaps a little bit more the relationship between obtaining this actual knowledge and then doing something. How's that interpret? Like how this is important for legal certainty for companies too. They need to know, if something does come sort of up and they obtain actual knowledge, like what does that mean in terms of acting expeditiously? So I think that relationship could be perhaps, and the DSA is, I think, the right forum for it, could be clarified, maybe in recitals, who knows, or maybe in articles.
Thank you. Very good clarification. Gabriella, any reactions again to the chat if you want, to the questions in the chat, but just choose the questions that you feel most comfortable with.
Just very briefly, though, I have to say on the content agnostic, I think that's correct. But I should also point out that in the DSA you do have a provision for codes of conduct, and the codes of conduct are there to deal with particular problems, which in practice tend to actually concern particular types of content. So at the moment, it effectively gives teeth to existing codes of conduct. So there's one on disinformation, and then there's another one on illegal hate speech. And there could be something else, but we don't know. So just to clarify that, I also wanted to say very briefly that certainly agree with the point about consistency. It's one of the big problems with the platforms and, how they implement that into search. That's why you need transparency. That's why statements of reasons are good. A statement of reasons also allows the preparation of an appeal, because if you don't know what the reasons are, it's very difficult to do. But I think it's also worth bearing in mind that consistency is something that has plagued the jurisprudence of the European Court of Human Rights, particularly on hate speech. It's very difficult to do because it's very case specific. And of course, there may be like broader considerations. I mean, we should all be pushing for greater consistency and disparities, because sometimes it seems to be down to political or economic priorities, or business priorities of the companies, or the geographical, because maybe the companies don't have quite the same resources in a particular part of the world as opposed to another, and so on and so forth. So all these things are important, but I think it's fair to recognize that it is hard to do, and it is also very much case by case. So I just wanted to add that very briefly. Yes, that I wish there would be more enthusiasm. Like, I hope we can get to a point with like the strongest safeguards possible on due process, but it's true that often what we have is a bit below what you would expect in the offline world. So I know that politicians are big fans of saying what's illegal offline should be illegal online, but I think you'd find that the reality is that quite often there's more things you can't say online that you would be able to say offline. And effectively, the sort of systems we're looking at in terms of safeguards, like what Alexandra was talking about, like having this opportunity to respond and so on, in the offline world, that's not how it would happen. You wouldn't be like, you wouldn't be shut down or have your account suspended or something happen without you having your day in court and being able to say, have an exchange, and so on. So it's just just to throw that out there. Now, I'm just going to try and address some of the questions. I'm afraid I'm also not an expert on the GDPR. But what I can say, as a matter of practice, is that whenever we ask for access to data, the companies are adamant that data protection legislation, and quite so often imply the GDPR, is an impediment to that access. And presumably it's because they see some legal risk in it, so that if they disclose certain things, it's probably because there's something that's not entirely clear. So perhaps one way to look at it is just to really mandate the disclosure of certain data and work out like the best wording to kind of accommodate the balance of interest in here between transparency and the protection of personal data. Now, as to the question whether the DSA protects against illiberal state authorities in the EU to force platforms to suppress expressions of dissent by critics or opposition. Well, it's, I mean, there's no obvious provision on its face, I would say. I think like part of the issue is often in relation to the substantive law itself, because there might be more speech that's illegal in those countries to begin with. So obviously, I mean, I think some of the concerns that you might have is perhaps if you have, certain states and they have like, enlist sort of troll armies to file lots of like notices. And because of the problems I was alluding to earlier, that leads to removal of that content. I guess that's where you have like the provision in the DSA about abuses around that, but it may still be a bit difficult if the substantive law itself is quite restrictive. So that's certainly an issue. And then the second type of provision, which is again a little tricky, is it's just accommodating what the domestic law might say is unlawful with what we would say should be permissible under European human rights law, and how you find a way of making that argument so that the content can then be, can stay online. But that would likely be quite complicated to, you'd have to look at the balance of all these different pieces of legislation, like if things are removed under the law, if they're removed under terms of service, and then there's the whole discussion we were just having around must carry of certain types of content. I mean, technically speaking, like the case for the European Court says that, you know, you shouldn't be forced to publish certain things. And if that thing is illegal, I think what you hope is that there's an avenue domestically where you can challenge that effectively, so that you may have an opportunity for that content to stay. But I can't really think of any other provisions per se, but perhaps Alexandra will have some ideas. But like certainly what you would want at the very least is, you know, ensure and have like independence left, right, and center when it comes to decision making, to try and ensure that, and access to the courts, which I also realize could also be a problem in some countries. So, and here I'm just, I'm not sure what other solutions there might be there. Perhaps.
I apologize, but we are
yeah, almost at time. So maybe I'll stop here. I'm happy to take next something maybe about the oversight board, or, you know, just
yeah. It is even more tragic. We are already at the last remarks stage, because we have 11 minutes to go. So I'm going to give you one more round for any final thoughts. It illustrates that we should have organized the whole day, but it's too late now. People probably have other meetings and other jobs to do after us, so we can't start postponing now for the whole day. I mean, we can't continue for the whole day. So I'm going to do in order: René, Alexandra, Gabriella. I ask you if you have any final remarks. Sadly, apologies, audience. We didn't have the chance to get to all your questions. I apologize. Next time we'll organize a longer event. Yeah, guys, so please keep it brief, and we'll just organize more events. René, final remarks?
Yeah, maybe briefly, I think two. One on Alexandra's point, and also one on Gabriel, sorry. But starting with Alexandra, because you said something about a blog post that you wrote on this Trump decision. I think you said, and I thought it was a really interesting article, you said that freedom of speech is not necessarily freedom of reach. So, and I think I kind of, you know, in the context, because we get a lot of these Trump ban questions as well. And I think that is sort of a good way of sort of looking at it too. You know, as long as a person is still able to have freedom of speech, not necessarily on that platform, but maybe somewhere else, then his freedom of speech is sort of, you know, protected in a way. It doesn't mean that, you know, the reach isn't really, I think sometimes maybe people confuse that, and that's sort of how I read your article at least, but maybe I interpreted it wrongly. So please let me know if that's true. And with Gabriel's comment on the audits that these very large online platforms have to do in the DSA on these sort of mitigation measures that they have to take, you know, like with respect to this, you know, intentional manipulation of their service that may have an impact on the civic discourse. So in other words, there's some harmful content related aspects there. I think there the issue, or what's really important, is to ensure that these audits are done by independent organizations. And I think, again, I would underline that, you know, much of the discussion will probably also lie in the fact that you have to look carefully and closely at what independence means, and you might have to spell it out just to ensure, you know, there isn't any sort of greenwashing or non-legitimate sort of measures that are being taken. Or automatic boxes that are ticked, sort of. And then thirdly, I would say lastly, maybe a very quick point on what was said also by the new UN Special Rapporteur, because I think someone mentioned David Kay. You know, now with Irene Khan, of course, succeeding him, she wrote a report on sort of freedom of expression and opinion in relation to disinformation, and we briefly touched upon that. She also mentions that, you know, of course, there are some issues on online platforms that we see manifested, but she says, you know, she also says, look at all the underlying factors, you know, the societal ills. And I think the same applies to the DSA, and I would sort of encourage people to also look at it that way, because the DSA is only one instrument of many sort of instruments that the EU is going to propose or has proposed, like, for instance, the EU media and media audiovisual action plan, I think it's called, and the democracy action plan. So all those, you have to sort of see the DSA from a holistic perspective and see it in the overarching sort of digital policy mandate that the EU has created, focusing not only on issues that manifest themselves on the platforms, but also the underlying factors. So I'll leave it at that. Thank you.
Thank you very much, René. So far, by the way, I get the impression that most of your comments could be very broadly summarized as pretty good try by the European Commission, but serious room for improvement. But we're still lucky to live in a continent where proposals are at least a pretty good try. Alexandra and Gabriella, first Alexandra, but looking at the clock, please be brief. And again, apologies, okay. Audience members get their answer. My fault, not attendee, not as panelist.
I guess, okay, I will throw in that the Trump amendment from the report just because it made my blood boil, but it does link to what was said about the freedom of reach and the power of politicians to actually, to exercise their freedom of expression. So it's that report of MEP Schaldemose from 2 or 3 days ago, which adds that, where online platform decides to suspend the provision of its services to a recipient of a service whose account is of public interest, the online platform must receive the approval of the relevant judicial authority before applying its decision. And, for me, that sounds like, okay, it's not a must carry obligation for heads of state, but it does give more protection to politicians because it's a higher standard to block their account or to remove. And for me, we have to remember that, okay, political speech is more protected, but political speech is not only speech by politicians. And the whole idea of freedom of expression in democratic society is exactly for those who are not in power to speak truth to the power, to say things that those in power don't want to hear. And here, it's kind of this reverse situation when blocking or removing content by head of state becomes more difficult than someone who is, for example, in opposition and is criticizing. So for me, that is a very dangerous way to go. And that's why I think, in terms of indiscriminatory or equal application of those terms and conditions, this is where it comes to play. So for me, I just wanted to say that because it's been bothering me since I saw that. But in terms of, I guess I'll just say one more quick thing. In terms of GDPR, it's also not exactly my topic, but for those interested, I encourage you to read the opinion of EDPS on the DSA, where it does address certain issues of what could be problematic from the perspective of data protection, specifically talking about, I think, specifically focusing on targeted advertising, possibly recommender systems, targeting content on the basis of profiles built on collected personal data. And my final state, well, I guess I've said it already. It's great that DSA has so many safeguards, definitely room for improvement, but at the same time, I guess, I think it's similar as with the terrorist content regulation. It's loaded with safeguards, but it's also, we should not think as safeguards as a way to legitimize certain regulations that are not proportionate, and that you won't address everything with just procedural safeguards. That's it. Thank you.
Thank you so much, Alexandra. By the way, in the chat, some people are asking for a link to your blog. Perhaps you could put that in there. Then, Gabriella, final, quick, last remarks.
Thanks very much. I mean, I think it's fair to say that the DSA is it's changing the sort of conversation we're having on many aspects of content moderation. I'm not entirely sure that the notice and action part of it is one of those. It feels more like a rehash of many things, we've been discussing over the years, with many of the same problems that keep on coming back. I hope we can find solutions. I do think that there is a problem. I mean, there's, I think, two issues. I'm not sure that politicians necessarily see the dangers for free expression, because, as Alexandra said earlier, people only ever notice that it's a problem when it's their speech that gets taken down. And so what we're trying to do is push for these safeguards for everyone to have a voice. But sadly, I think very often people think everything's fine, it's all very reasonable until it happens to them. And I think there is this potential, because a lot of the things that, at least so far, and perhaps the DSA will help change some of that with the database, with statements of reasons, but very often it's not very visible. We don't know how much is removed. And so I think, like, we don't really know, also with recommender systems and so on, how much conversations don't really get surfaced, and how much we're still able to have discussions about controversial topics. So I hope that in future, as the DSA, I'll just wrap up, as the DSA conversation continues, I hope there'll be better recognition of that as we discuss, like, the various provisions within it. Thank you.
Thank you so much, Gabrielle. It's really tragic that we didn't book a seminar of 5 hours or a whole day, but yeah, we'll do that for the next installment. So thank you so much, speakers. A big applause for you. Thank you for all the people in the audience for coming by. In some countries, very nice weather, so that shows that you have a lot of discipline to listen to a detailed, hardcore legal panel. And I know that you are all busy, so thank you for coming, and I'll leave it at that. Have a good weekend, everybody. Bye.
Thank you very much.
Thank you. Bye.
Thank you. Bye-bye.